So you have to include things like the expected date of their employment loss. Oh, okay. Yeah, the effective date of the first employment loss and the employee's particular date of employment loss. So if an employee is scheduled to be in, sort of round two, you still have to tell them these are going to start on this date, and then your expected termination date will be this other date. You have to describe whether it's permanent or temporary. Keep in mind that although most of the employment loss scenarios are permanent loss of employment, you could have some employees who are affected by way of 6-month layoff or reduction in hours of work that is not intended to be permanent, and you would have to explain that to the extent you can. Whether bumping rights exist, this is under both the federal and New York statute, and what bumping rights mean, will some more senior person have the ability to displace a less senior person. Often in a non-union setting, there's just no bumping rights to deal with. Plant closings, there usually wouldn't be bumping rights because everyone is losing their job. If there are seniority issues, and that means that there might be union issues. It is possible that there would be issues that have to be negotiated with the union. The union can't negotiate away your right to, or your obligation to provide the notices if the law otherwise requires it, however. But you might be obligated in some cases to at least negotiate over the effects of your reduction in force, which you might or might not be able to or need to do before you issue the WARN notices. The other wrinkle on the WARN notices is if there's information that you don't know at the time you issue the notices. Remember, in New York, that's supposed to be 90 days before the first employment loss happens. Then you have to issue subsequent notices if and when the additional information becomes known, or probably if it materially changes as well. You have to provide the name and number of a company official to contact for more information, and regulations from the state of New York under the New York WARN Act require companies to include information about unemployment insurance, job training, etc. There's actually a paragraph that they include right in the regulations that you should just put right into the notices. That's a minimum requirement. You can give more such information, but that requirement is not something that existed under the Federal WARN Act, and is another one of the differences between the two. But of course, including it in the notice would not be a problem under the Federal WARN Act. You can add additional information there as well, so you don't and normally wouldn't. You don't have to and normally wouldn't give separate notices to separately comply with the two statutes. You also, by the way, don't have to state in the notice that I'm hereby telling you all of this to ensure that I comply with the New York State and Federal Worker Adjustment and Retraining Notification Acts. You just need to give them the information that the laws require.